Your Honor, this is a series of bail reviews out of the Stoughton District Court, the Commonwealth versus Aidan Kearney.
Good morning, Your Honor. Timothy Bradle on behalf of Aidan Kearney.
Sir, you may be seated. So it's 9 total bail reviews. It looks like they all present the same issue. I received only this morning a petition for review of the District Court bail determination, which is basically a memo in support of the argument that the stay away, no contact order should be lifted. Mr. Mello, did you see this?
I received it at 4:42 yesterday. It came my email, Judge. I have not had the opportunity to respond to it.
Okay.
The government's prepared to go forward.
You're prepared to go forward, or do you want an opportunity to respond to it?
If Your Honor needs a response, I can respond in writing.
Well, I mean, it obviously raises interesting First Amendment issues, novel issues that aren't regularly dealt with in a bail petition.
I believe that, Your Honor, views the Commonwealth presentation, you'll agree that First Amendment issues are not why we're here.
The First Amendment issues are the issues that are raised in the petition, though. So if you're going to, if you want to address that, it would.
I certainly can, Your Honor.
Well, how do you want to proceed? Do you want to proceed now, or do you want to have an opportunity to brief the issue, the First Amendment issue, which is raised in the petition? That's what's raised in the petition, is the First Amendment issue.
Correct. I can, if Your Honor, rather than rescheduling this, we can proceed with the hearing today, and if Your Honor would direct me to do so, I'd have a memorandum in court to file that within the next.
Well, all right, let me flag the issue, but let me hear from Mr. Bradle first about whether we should go forward or whether, because nothing is before me on the merits of the case in Stoughton. I've read the files, I've read the reports, okay, that were included in the files. I'm not particularly interested in a presentation of what the merits of the cases are, okay, although that relates to whether a stay away, no contact order should be issued. But I am interested in the First Amendment issue, which is raised by Mr. Bradle. So if you're not prepared to address that today, I think we probably ought to put this over. So, Mr. Bradle, I take it you are only looking to lift the stay away, no contact order, not modify it, not limit it. Obviously, in this kind of a case, a stay away, no contact order would be almost automatic. And the only reason that I think there is any basis to challenge it in this instance, it seems, is the First Amendment issue.
Here's my take on this. The government brought these charges. They're unprecedented. The government ought to have been prepared to defend their suppression of the First Amendment. By statute, the defendant should be taken before the Superior Court, even that day, the statute says, if possible, or the next day. And in this case, certainly there's novel issues, so we took a few extra days, and I certainly don't object to that, don't have a problem with it.
All right, well, I'm not dealing with the issue of delay and timing. I mean, you filed an appeal on the 18th, petition for review of the decision, which was a week after it was issued, and you only filed your brief or petition, your memorandum raising the First Amendment issues after we closed for our business yesterday, and I only read it this morning. I understand the importance of the issues. I'm happy to have the Commonwealth brief it adequately. I'm happy to have you give me any cases that you say justifies the withholding of a stay away, no contact order in the context of a witness intimidation case.
Sure.
Where there are First Amendment issues involved. But the issue of timing is not really particularly relevant given the timing that the defendant chose with respect to seeking review of the no contact order.
So if I may, Judge, my thought is that 99% of these bail reviews, nothing gets filed at all. So I took advantage of the delay in being able to get into court to file something to assist the court. So I feel badly that it may cause delay for my client. Most of the time, the parties just come in and argue without the benefit of a memorandum. And here, I spent some time to try to get a memorandum to the court and to counsel as best I could. It's a thorny issue, it's a novel issue. It took quite a bit of work to kind of get something together. I want to ask the court to look at it as an addition, a help to the court, not something that should cause delay for my client. Usually we don't have these at all. So I filed something to assist the court.
Do you have a case? Do you have any case where in a witness intimidation context that raised First Amendment issues, the stay away, no contact was not issued or was viewed as overbroad?
Well, I think the Brangen case, Judge.
Brangen involves detention, right?
Right, but Judge Lenk, she talks all about the constitutional issue here, about how these orders need to be narrowly tailored. They need to serve only a compelling state interest. And we're not here asking if he can go play softball on Saturday. I was in Suffolk Superior yesterday asking a judge there to let a guy go work at a restaurant beyond his curfew. This is a totally different animal. To answer your question, there are no cases right on point in Massachusetts about journalists and witness intimidation and the First Amendment. So you have to look to analogy. As I stated in my brief, Judge, O'Brien v. Borowski, I'm going to predict that's going to be the law on this. is O'Brien v. Borowski. It's going to have to be fighting words, true threats, and the definition of fear cannot be, I'm afraid they're going to destroy me by suing me. I'm afraid they're going to sue me. I'm afraid they're going to get me locked up for things that I did. That's not the kind of fear that can be suppressed by the government by filing a witness intimidation case. So that's what I want to invite the court to look at.
So your view is that a journalist can bring a dozen other cars, honking horns in front of the neighbor, in front of a witness's house, and calling out to the neighbors to call on their neighbor to do the right thing.
Well, it's not something that plays well in polite society. I wouldn't do it. You wouldn't do it.
Is that's what you say is journalism? That's covered by the journalistic privilege. That is to say, it's covered by the First Amendment.
Covered by the First Amendment, Your Honor. Absolutely. In Article 16.
Even if the other dozen cars or however many cars go out are not.
I'm sorry, are
not journalists.
Not journalists. Well, Judge, that involves another issue that's a difficult issue, but should really come out on Mr. Kearney's side, where how much control does he have over his people that follow him and want to cheer him on? Who can control a mob?
According to the papers, there was a meeting place.
Yeah.
And no one knew where they were going in advance.
But these are...
And then this defendant, I'm reading between the lines now, I don't think the papers are explicit, but they suggest that this defendant then directed them to the various locations that they were going to drive by.
Sure. That's completely constitutionally protected. Just to demonstrate against what you see as government corruption. So this deserves the highest level of First Amendment protection, Your Honor.
I understand the argument. Mr. Mello, are you prepared to address the law?
Not to the extent that the defendant has raised in his memorandum. However,
would you like an opportunity to brief the issue?
I would, Your Honor.
All right. When would you like to have the hearing after you have briefed the issue?
Whatever's convenient to the court, Judge.
I have here every day next week. All right. Can counsel on the Aidan Kearney matter identify themselves for the record?
Good afternoon, Your Honor. Kenneth Miller for the Commonwealth.
Okay.
Hello, Your Honor. Bradel on behalf of Aidan Kearney.
Since our last meeting, received the Commonwealth's reply and opposition to the defendant's petition. I received a supplemental memo from counsel for Mr. Kearney, and I received a supplemental affidavit from Mr. Kearney. Should I have received any other documents?
That's it, Your Honor. Those are hard copies of those documents before you there.
All right. The supplemental affidavit of Aidan Kearney contains various links to things which are electronic and not in front of the court. I don't take cases that way. I don't take exhibits that way. I can't, because things are fluid on the internet, and we need to make a record of anything that's submitted to the court. So if you have these YouTube videos or something on a disc, I'm happy to look at them, but I am not going to look at things that are on the website here today, gone tomorrow, or anything like that. I'm not suggesting anything would be taken down, but the record has to be clear for an appellate court to review, and so I do not have a thumb drive or anything else with any of these links or items to which there is a link in the supplemental affidavit. I know you purported to file something electronically, but I cannot take exhibits to a document electronically. Do you have them in a form that I can take and make a part of the record?
Sure, Judge. I'd be happy to put them on a thumb drive and we can make an exhibit.
Okay, when can you get those to me?
I'll do that tomorrow morning if you like.
Okay, we'll take those as an exhibit. Just make sure they cross-reference the paragraphs in the affidavit. So supplemental affidavit, paragraph 2, for example, references a YouTube video. And if you want me to watch that video, you've got to give it to me on a disc, and it's got to say paragraph 2, okay?
Happy to do it.
Something like that.
No problem.
Okay, thank you. Now, I've read all the papers that everybody filed. Thank you for the effort. I'll hear from Mr. Bradel first, and then I'll hear from Mr. Mello.
Thank you very much, Your Honor. Your Honor, this is not your everyday bail review. Your Honor sits in full de novo review of this ruling, and this is not the kind of case that a stay-away order times 8 against a journalist should stand. The Commonwealth sort of looks askance at the First Amendment arguments here and wants to just treat this as a sort of a regular case. This is not a regular case, Your Honor. This is an unprecedented prosecution. The Commonwealth, I think, is sort of lost in the fog of war on the Karen Reed case. And as a result of that, they've been criticized, they've been taken to the woodshed, if you will, by Aidan Kearney. And the very same squad of detectives that have been investigating that case, that have been roundly criticized, exposed, investigated by Mr. Kearney, they themselves have used the mechanism of the state to bring these charges. These charges are so unprecedented, Your Honor, that there's not only a First Amendment barrier to these charges, there's a due process barrier to these charges. The government, this is in my supplemental memorandum, Your Honor, the government cannot take long-standing behavior that is...
So this is a new argument that the Commonwealth hasn't been able to address. You filed an initial memorandum. It raised First Amendment issues. Then you filed a supplemental argument, supplemental memo concurrent with the Commonwealth's filing. They addressed the First Amendment issue in their brief, but they didn't have the benefit of any due process argument. Now you're advancing a separate argument, a due process argument,
Your
right?
Honor, Mr. Kearney has a 100% right to remain silent in this case.
Yeah, you don't have to advance any arguments. But if you are going to advance arguments which are complicated, sophisticated, and out of the ordinary, which is what you're arguing, you have to at least give the opposing side the opportunity to address the arguments. The arguments were framed by you under the First Amendment. I wanted the parties to address those in writing. Mr. Mello addressed those in writing. You also, to some extent, addressed them in writing, particularly Mr. Kearney's affidavit addresses them. But then you raised an entirely different argument in your supplemental filing, and I'll hear you now on it, but Mr. Mello may want an opportunity to address that new argument.
I have no problem with that, Your Honor.
Okay.
My thought on this, Judge, is just that if the government is going to explore into unknown worlds of prosecution, that they ought to have their arguments together as to why it fits under the Constitution. We're trying to defend against the government here. They have the burden to establish their case. They have the burden to, especially where they're going to try to create an entirely new realm of liability that involves fundamental rights. I would think they would have their ducks in a row to be able to defend it.
So let's talk about the due process argument. I think I understand your First Amendment argument.
Sure. Thank you, Your Honor.
Let's talk about the due process argument. You say that your client doesn't know what's off limits.
That's
right?
correct, Judge. No one knows it's off limits. And I'll show you this in the thumb drive. There's hundreds of examples of reporters never been prosecuted or criticized even for showing up at people's sporting events, showing up at people's houses, taking video, asking tough questions. Those are the people that need the protection, Your Honor. The government, again, in the fog of war on the Karen Reed case, that's why they're doing this, because they're the ones that are getting exposed. There's never been a prosecution like this, Your Honor, so there can't be any fair notice to this. This is behavior that is flashed across news screens all the time. Every journalist in this room probably has employed sharp tactics from time to time, getting in people's faces, showing up in people's driveways. It's not witness intimidation. And
You think a journalist can call up a witness and say, it's Turtleboy from them Advantage Boys, bang, 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 fuck any of you dogs up. You think any journalist can call up a witness and say that and not have it be construed as witness intimidation or a threat? You think that's the law?
yes, I do, Your Honor. Political hyperbole is protected. There was a case in the 60s, Judge, where someone that was against the draft said that if you put a gun in my hand, the first person I'm going to go after is Lyndon B. Johnson, and the Supreme Court held that was political hyperbole. It is protected, Your Honor. It's very broad. And again, polite society might not like it, but frankly, at this point, Judge, I'm tired of talking about, gee whiz, we don't like this behavior, but gee whiz, I wouldn't do it, you wouldn't do it. Let's just talk about the First Amendment here. Let's talk about due process. Let's talk about the government's motives in doing this, which are to protect themselves from being exposed as in an investigation that stinks. That's what's going on here, Judge. This isn't someone who is spewing hate. This isn't the KKK in Brandenburg. This isn't the Nazis in Skokie. This is a journalist doing good work, exposing corruption, exposing the government. So it's not even people spewing hate speech, which is all protected. He's speaking out on matters of public concern. And in matters of public concern, the protection of the First Amendment is at its zenith. So back to the due process argument, Your Honor, there's nowhere that any of this behavior has ever been prosecuted. And the cases that are cited by the government are all an opposite. They involve family members of defendants intimidating people in courthouses. The government cites Brandenburg, which protects the KKK. The government talks about harassment a lot.
So you're backing into the First Amendment. Question is, what's the due process challenge?
The due process challenge, judges, there's no fair notice that this was a crime. That's it. It's
All right.
cited in there all over the place.
Okay, all right, I'll hear from Mr. Mello.
Thank you.
Good afternoon, Your Honor.
Mr. Mello, go ahead.
Record, the fair notice that this was a crime is contained in Mass General Laws, Chapter 268, Sections 13A and 13B. It's extremely clear that the general court has prohibited the acts which would interfere with witnesses in criminal matters and in civil matters as well, and has prohibited, for instance, in the instance of the rolling road rallies that Your Honor referenced earlier, has prohibited that type of conduct. You cannot picket or protest outside of a witness's home with the purpose of, intimidating or influencing them in any way. Chapter 268, Section 13B, which is set forth in our memorandum, and I'm sure Your Honor was certainly aware of all of the criteria set forth there, there's a long list of individuals described, including family members of witnesses, and they don't even have to be witnesses, Judge. They could be potential witnesses. The statute's pretty clear that cannot be or protected from intimidation. This is not a First Amendment case, Your Honor. The defendant has stated alternatively on many of his blogs and his other internet sites that he is a journalist, an activist, and a satirist. The general court, in setting forth the language under Section 13B, clearly was looking to prohibit things such as walking up to someone's front door where a storm door with a glass front is closed but the interior door is open, from walking up to that witness's door and videotaping the interior of the house. The general court clearly intended to prohibit someone from attending the sports games of children of witnesses in cases. It clearly intended to prohibit an individual from chasing a state trooper across the street outside of this court with a bullhorn. This is not journalism, Judge. This is activism. This is whatever you may call it. And certainly the government is not looking to define how journalists should conduct themselves, but when you look at it, you can see that this is not what they're defending for. They're not defending journalism.
We can talk around the edges about whether things are or aren't journalism, and we can talk about where the line is, but clearly Mr. Kearney is reporting from his perspective on things related to the Reed case and putting things on the website and blogging about it. One can talk about the tone, one can talk about the content, but clearly he is reporting on matters of public interest, not in a way sensitive or sympathetic to the Commonwealth's position, but clearly there's a First Amendment interest in at least some of his actions. The district court judge issued an order saying that the defendant had to stay away from 7 different individuals and lists those 7 individuals, but didn't articulate a distance from those individuals, which creates an ambiguity for Mr. Kearney about what he can and can't do or where he can and can't go when those individuals are in the vicinity. That seems to be an ambiguity that does limit what he can do and seems like something the court should correct. What do you say to that? So the judge wrote, he put a check mark next to stay, and then it says distance, and then there's a blank line, and then it says away from, and he wrote in names. So Mr. Kearney reasonably would not know how far he has to stay away from those individuals. What do you say to that?
The Commonwealth considered that in its conclusion, in its memorandum, where the Commonwealth further requests that the Superior Court impose any further conditions of bail on the defendant as the court may deem appropriate. That was intended to include such things as a distance, a stay-away distance. Given the fact that the defendant has gone so far as to use a bullhorn and has shown up at sporting events, school sporting events, and has gotten thrown out of those events because of his actions, I would ask Your Honor to set a 500-foot distance from which you can no longer approach these individuals.
No, we're not talking about the no contact order, okay? If Mr. Kearney were to get on a bullhorn and call out to witnesses or call out about witnesses in a way that would be direct or indirect contact, that would be problematic. But I'm talking about where he can go when those individuals are nearby. And 500 feet is a distance that, frankly, never seen a court set. It's a pretty long distance. And so I'm just trying to understand the reasons for a distance that you would suggest.
The reason for that distance is because in these instances, if he was within 500 feet on a bullhorn, he would barely be audible at that distance. And that's, I'll grant you, Judge, that's subjective. But it seems to be reasonable because certainly within 100 yards, he can well be heard if he's advocating for one cause or another within the distance of these witnesses. Nonetheless, Your Honor referenced his posts on social media, the government would be the first to come before the court and advocate for the right of anyone to post on social media. And however, the limitations there have been well established by law for decades and perhaps centuries in the United States. A journalist, by virtue of one being called a journalist, that does not confer upon an individual the right to break the law. It's not a license. You have certain freedoms that you can demand be observed, but those freedoms do not extend to harassing witnesses, harassing their children, etc. Your Honor received, as a supplement to the memorandum, a report or statement from Detective Lieutenant Tully.
Hold on one second. Let me just see. Go ahead.
And there are that's only a small number of some of the incidents that have occurred by virtue of actions of the defendant. This particular individual approaches people in a way that where he says, I'm not a threat to you, I'm not going to cause you any harm, but his actions are contrary to his words in many cases. He's called people and indicated, in one instance to one of the witnesses, has advocated on his pages, his web pages, has advocated for people to call the employer or to post on the employer's website, clearly intending to cause some economic harm to that witness and jeopardize her job, hoping that, I would say by extension, you could assume that they would hope that the employer would come down on that particular witness for having brought that type of notoriety to the company. There are other instances where, he's advocated for people to go to the business of an individual witness and order things and seemingly not pay for them. Those have all been advocated for by this defendant. And that's the economic harm that a witness would suffer. In one particular instance, one witness who owns a pizza shop in Canton has reported a marked increase in the number of orders called in that were not picked up. And that's because this defendant has advocated for that. There are other instances where he has approached people and stated online, life as you know it has changed. You won't be able to go anywhere without being photographed or followed. We know where you've been. There are instances where he's conspired.
I appreciate that. I read the underlying documents that were filed in support of the complaint with respect to the 9 cases. Let me ask you this too. Mr. Kearney objects to the stay away, no contact because it says he will not be able to be in the same place as the witnesses / victims, okay, who were named in the 9 counts in the Stoughton District Court. Do you agree that he should be allowed to attend proceedings in the Reed case here to the extent he is conducting reasonable journalism?
Yes.
Okay, so we should we should allow him to attend those hearings, and that should be made clear in whatever conditions are set.
And Commonwealth would agree to that, Judge.
Okay,
yes.
All right. So that would be an exception to, if I were to select 500 feet, to the 500-foot stay away condition so that he could attend court proceedings.
Yes, sir.
Okay, if I adopted the 500. Okay. Anything else you want to add?
No, Judge, other than for the fact that in this case, and I don't need to repeat myself, the representation that this is in any way stifling to journalistic activity does not carry any weight, Your Honor. There are 2 statutes on the books, particularly that have been violated more than anything else, and that is the statute of harassing and intimidating witnesses and their family members, as well as protesting or organizing, etc., around their homes. And that's as precluded by 13A. And you can't hide behind the shield of a journalist to break the law. And an example I have thought of is if this particular defendant were following a story, an allegation that a bank in the community was passing counterfeit currency, would not give him the right to break into that bank and to break into the vault to check for himself. There's a law in the books that precludes that or prohibits that. Same here with intimidating witnesses, Your Honor. Same here with protesting in front of their homes.
Okay.
Thank you, Judge.
I'm going to get something from Mr. Bradel by tomorrow, plus or minus, and I will take the matter under advisement. It'll take me a little while to take a look at whatever Mr. Bradel submits tomorrow, but I'll take the matter under advisement. Okay?
May I address just a couple of things raised by the...
Sure. Mr. Miller, you can have a seat.
My last point, if Your Honor is going to accept additional evidence...
No, the only additional evidence I'm going to accept is a copy of whatever is linked to in Mr. Kearney's supplemental affidavit.
What I was going to state to the court is, if Your Honor would like, we were prepared at our last session to show the court some video clips that would exhibit the type of conduct that we believe is a violation of the law. If Your Honor would require us to do so, we can...
I've read the documents. I don't require it. If you have video clips that you want to submit to me, you could have submitted them to me already, and I'm happy, if there's no objection, to take them at the same time I take something from Mr. Bradel. Mr. Bradel, what's your view on that?
No problem, Your Honor.
Okay, if you want to submit some video clips for me to watch, you can submit them to me by close of business tomorrow as well.
Thank you.
Okay? Okay, Mr. Bradel, go ahead.
Thank you very much, Your Honor. I wanted to address the quote that you brought up that sort of out of context sounds like it's something that might trouble the court. And what was really going on there, Judge, is that Mr. Kearney was calling a witness and satirizing his threatening video that Mr. Kearney had seen. And Mr. Kearney was mocking that and repeating that back to him, what was said by the witness, roughly stated. And he then shifted in that conversation into leaving a message about the Reed case, asking journalistic questions about the case. So that's what's going on there. There was no attempt to threaten or violate the witness intimidation statute by satirizing the witness's own statements back to him. So
what the intent was will be for a jury to determine. I'm faced with the statements, okay?
Sure. And I just wanted to give context in terms of there's a number of factual disputes about what's going on here. The government,
I'm sure there are.
And the government says that he videotaped the interior of witness homes without their permission. Judge, walking up to someone's door, knocking on the door while the camera's rolling happens all the time in journalism. And if the door's open, you're going to see inside the house. People can put up a no trespassing sign. People can keep their door shut. But if someone walks up to the door, if a journalist walks up to the door with news cameras without any no trespassing signs, that's protected by the First Amendment. If something inside the house that's open to plain view from the street gets videotaped, that's not a crime. That's not witness intimidation. It's protected by the First Amendment. This is a series of things that the government cites, just flatly cites behavior and expects a court to look at it and go, yup, that's witness intimidation. It's not witness intimidation. It doesn't satisfy the First Amendment. The standards in O'Brien versus Borowski for harassment, Your Honor, they have to apply here. They can't not apply. So I'm asking you to apply those. And whenever you look at any of these factual nuggets that the government wants to say is witness intimidation, they abjectly fail under O'Brien v. Borowski, under the First Amendment, and they should not be credited as witness intimidation.
Harassment is one provision of the witness intimidation statute.
Yes.
But willfully threatening or attempting or causing physical, emotional, or economic injury to witnesses is another element of the witness intimidation statute.
Yes.
When you publicize somebody who is the wife of an investigator's job and you say to my followers, call this job and let them know what you think about her, or I don't think that's the way it's phrased. I think it's more like, there are these open websites, get at it and post on those websites. I am very much paraphrasing. But that's the sentiment of the conversation that's posted by your client, as I understand it. That is not reporting, that's advocacy. That's encouraging people to do something to another party's economic disadvantage. When you tell my followers to go and call a restaurant and order food and don't go and pick it up and don't pay for it, and that's what happens, that's economic injury. It certainly may cause emotional injury too, but it's certainly economic injury, which is an element of the witness intimidation statute separate from harassment. So I don't think you're telling me that first clause of the witness intimidation statute does not apply in a First Amendment context. It sounds to me like what you're arguing is that the actions by your client did not attempt to cause emotional or economic injury. That seems like what you're arguing, but I want to make sure I understand clearly what it is you are arguing.
I appreciate that, Your Honor. That's part of what I'm arguing, absolutely. But the second part of it, Judge, is that if you look at the analogous framework in O'Brien v. Borowski, economic injury is not allowed. Economic injury violates the First Amendment, criminalizing that. You're allowed to boycott. You're allowed to urge people not to do business with someone. You're allowed to say to people, I'm going to sue you and destroy you. You're allowed to do that. That is prohibited under O'Brien v. Borowski in the harassment context there. There's no reason why that shouldn't be applied here, Your Honor.
Okay, are you aware of any situation where that case's description, that case's ruling in the 258E context was applied to the witness intimidation statute to say that nothing other than what constitutes actionable harassment under 258E can be enjoined or prosecuted or constitute a crime under the witness intimidation statute?
There is no such case, Your Honor, and that's what I'm inviting this court to do on the merits, looking at the merits of the case in the context of whether collateral order should issue. I ask that you find that it's unconstitutional, that those activities are constitutionally protected by the First Amendment, that you can threaten economic injury to a witness, and it's covered by the First Amendment. Absolutely. That's why the court, in the analogous context in O'Brien v. Borowski, truncated it to threats, fighting words, and the fear can only be applicable to bodily injury or property damage, not economic injury. That's something for a civil court. That's something to be hashed out in the marketplace of ideas. And that's my position on that, Judge. The law there is going to become the law here, and I hope it happens in Dedham. I hope it doesn't have to go to Boston or Washington, D.C., but at some point I have to urge the court that that's going to be the law here, that these statutes are incredibly overbroad. They inhibit freedom, they inhibit the First Amendment, and they need to be stopped.
Okay.
Thank you, Your Honor.
Thank you. I'll take the matter under advisement. I'll get whatever I get tomorrow, and you get a ruling from me. Okay? Thank you.
Thank you, Your Honor.
All right. Thank you. This court is in session. You may be seated.
Matter of Aidan Kearney, this matter is scheduled today for motion.
Hello, Your Honor. Timothy Bradel on behalf of Aidan Kearney. This is my client, Aidan Kearney.
Good afternoon, Your Honor. Kenneth Bowe for the Commonwealth.
Good afternoon. All right, so defendant's emergency motion for protective order.
Yes, Judge, that would be me, and so I'm the moving party, if I may be heard.
I'll hear you.
Thank you very much, Your Honor. Your Honor, I know you're familiar with Mr. Kearney as he's appeared before you before as a respondent in a criminal harassment hearing. That was brought, and that concerned journalistic activity in his capacity as a professional investigative journalist, Your Honor, and you denied that motion for reasons that were surrounding the First Amendment and that his activity was protected by the First Amendment and did not constitute criminal harassment. These charges before the court presently concern many of the same cited activities, Your Honor. We contend that all these activities are protected by the First Amendment. We contend that this prosecution is entirely a pretextual, unlawful attempt to silence Mr. Kearney with the machinery of the state, Your Honor, and use this prosecution literally, Judge, as an excuse to seize his electronic devices. And that brings me to the motion that I'm here today for, Your Honor.
I'll just correct one thing you did say.
Sure.
This matter was before me on an individual's request for a harassment prevention order, a civil harassment prevention order. Did not have to do with criminal harassment whatsoever, just so the record's clear.
Thank you, Your Honor.
Go right
I
ahead.
appreciate that distinction, Your Honor. So here, Judge, we contend that this prosecution is pretextual in violation of the First Amendment and simply an excuse to seize Mr. Kearney's tools of his trade, his computers, his cell phones, the things that he uses and needs as a journalist that are just filled with a career's worth of journalistic activity, information from sources, all sorts of videos, compilations, research for ongoing stories, all sorts of things that directly implicate, Your Honor, privileged materials. And in this case, Judge, we're asking for two things before Your Honor here in the district court. Just to state the obvious, we're here on cases with district court jurisdiction There's 9 matters that are squarely before this court. And in connection with those matters, Your Honor, the state police have, at the same time they arrested Mr. Kearney on these matters, they executed search warrants for Mr. Kearney's person, for his vehicle, and his home minutes after he put his kids on the school bus. They took everything from his home that was remotely attached to any sort of electronic usage. They have his phones, his computers, etc. There's no issue whatsoever with respect to the authenticity of these devices or the source of the chain of custody of these devices. And we would certainly stipulate, and we don't even need to stipulate, that the evidence is that these devices were taken from his home. And there's no reason whatsoever for the government to be retaining these devices. As I'm sure the court's familiar, Your Honor, the forensic investigators in these matters, they don't work with the phones or the computers. They take what's called a mirror image of the devices. They put it aside. The devices themselves are never touched again. They take the mirror images and they work from the mirror images. I've had many cases where my clients' phones, computers were returned the very next day, 2 days later, because the investigators simply don't need them. They acknowledge that. In most cases, for some reason, that's not happening here, Your Honor. In fact, I actually have a murder case in the Norfolk Superior Court with the very same investigators, Sergeant Buchanan, who sees, in that case, he took my client's cell phone. He had it back to my client in 2 days because that's how they do it. They take a mirror image of the device, and then the device itself has no evidentiary value beyond the minimal notion that, they can raise it up in court and say, this is the device I took. And that's not an issue that is sufficient, Your Honor, to trump the First Amendment, to trump my client's rights to maintain his journalistic career and to protect a very large number of journalistic sources. And I'm going to give the court a little bit of background in terms of that, Judge. The posture of this case before Your Honor is unprecedented in this Commonwealth for a couple of reasons. First of all, Your Honor, all the activity that is just baldly cited in the charging documents herein in this court as criminal activity is nothing but time-honored, journalistic, hard-nosed, investigative activity, Your Honor. Going to people's houses, knocking on doors, putting a microphone in people's faces, asking pointed questions, showing up at sports events. These things have been done thousands of times. Never have they spawned a criminal prosecution. Here, Your Honor, they're just baldly stated as evidence of some sort of criminal activity. In this case, Your Honor, Mr. Kearney has been investigating a case, I think it goes without saying at this point, it's the Karen Reed murder case in Norfolk Superior Court. The investigators on that case have come under scrutiny by Mr. Kearney. He has exposed them in many ways, and the viewpoint of it, whether you believe it or not, is immaterial. He has exposed them, he contends, we contend, they have covered up the fact that the principal investigator has a long-standing relationship with many of the witnesses in the case and targets in the case that are suggested by the defense team in that case, which we are not connected to. In any event, those very same investigators that have been on the receiving end of many embarrassing disclosures, potentially criminal disclosures, those very same investigators have charged him and arrested him and taken his devices, the very same ones who are under scrutiny. This is unprecedented, Your Honor, that these very same people would go and initiate a prosecution for lawful activity as an excuse to steal those devices and look in those devices. And that's what brings us here, Your Honor. This is very, very serious, Judge. That brings us to the preventive medicine case, Your Honor. The preventive medicine case was ignored by the prosecution here. As I know, I'm sure you read it. I know you have it. I know you read it. Judge, the preventive medicine case says that puts a legal duty on the government in such a case to go to Superior Court and say, Judge, we have a journalist's phones, computers. We have a case where someone has consulted with counsel. They may have communications from attorneys in the device. Here's our proposal, Judge. Here's our proposal of how we're going to protect those rights. And in this case, Judge, it was completely ignored. Mr. Kearney, and this is in my motion, Judge, I'm not going to read my motion, of course, but it's referenced in my motion, and Mr. Kearney swears as an affidavit at the end of the motion that he has, in his devices, he has consultations with attorneys. He's involved in 2 Superior Court cases and 1 District Court case before we even get to this case. He's consulted with attorneys, and this is all in his devices, about
the very issues here. How far am I allowed to go with respect to, investigating people? Is this a crime? Is this okay? Is this not okay? All this stuff's in the phone. More importantly, Your Honor, on this very Karen Reed case, there may be information in these phones from police sources who've come forward bravely and exposed all these alleged lies in the Karen Reed case. Now, these same investigators investigating the Karen Reed case are trying to get his First Amendment protected sources from all these devices. This is unprecedented, Your Honor. The very same officers under scrutiny have used the machinery of the state criminal prosecution system to get evidence. That's why we need the court to get involved, Your Honor. It's all in the preventive medicine case. If you just look at it, you'll see that they are required to go to Superior Court and present their plan for a taint team. Also, Judge, it's required under the case that the defense and the court are involved in the search. This is not something they can do to run an end around the First Amendment and to make an end run around the preventive medicine case, Your Honor. So that's the Superior Court aspect of this, Judge, is that they are the ones that have to, under the preventive medicine case, set up the screening team. However, Your Honor, as the judge in a pending district court case with district court jurisdiction, we're asking you to take the first step, order the Commonwealth to not search these devices until preventive medicine is satisfied, number one, and number two, return Mr. Kearney's tools of his trade, like in every other case where the data is taken out of the devices, these devices are sitting there in state police custody, and I think talk about a smoking gun, Your Honor, that proves what I'm saying, that they just want to keep these devices to stop Mr. Kearney from doing his job, to stop Mr. Kearney from continuing to investigate on the Reed case. It's a smoking gun. They want to keep the devices. In this case, there's no good reason why they should keep these devices, Judge, when they return them in every other case, including, coincidentally, the very same investigators on cases that I have with them, they return the devices. So there's absolutely no excuse. It's outrageous. There's no reason why these investigators should be retaining these devices, Your Honor. They have everything they need from them. They can search them all they want when they comply with preventive medicine. There's no hindrance to their investigative activities, Your Honor. And Mr. Kearney, on the opposite end of the spectrum, has every hindrance in doing his job, in accessing all of his documents, all of his electronic files, to investigate cases that he has ongoing, to continue to investigate the Reed case, where these devices are filled with sensitive data from the Reed case and his investigations in the Reed case, confidential private sources that must be protected, Your Honor. They must be protected. And to not let these officers get in there without a third-party team to screen these devices. Now, I know this isn't this court's ambit, but we're seeking a third-party screening team, not a team of assistant DAs, because in this case, Judge, the Norfolk DA's office has conflicted themselves out of the case, so they can't do it. There ought to be a third-party special magistrate who runs a team of people who goes through this stuff, and preventive medicine requires that all these emails and everything be disclosed to us on an ongoing basis. So this is quite a process, Your Honor. This is not something that is going to be a couple of days. This is an ongoing court-supervised search that is required by the SJC in preventive medicine, and the government has just completely ignored it. And if the government comes up here and says, "Well, we didn't know, Judge. We didn't know there was anything like that in these devices," well, they know now, Judge. You saw in my motion. Mr. Kearney signed an affidavit in my motion, at the end of my motion, adopting everything I say in the motion relative to the contents of the devices, Your Honor. There's your factual assertions about how these devices have these things in them. So that's where that is. And that more than establishes the need for the preventive medicine protocol to be brought to bear. There's also one other thing that the government has tried to do an end run around, judges, and this, they can't say they didn't know this was in there. And that applies to journalistic sources, Your Honor. I believe it's on page 4 of my motion, where I talk about, in addition to potentially attorney-client privilege materials, the First Amendment requires that before a court orders divulging source and information gathered, that the court has to do a balancing test, and the court needs to consider the effect of compelled disclosure on the values underlying the First Amendment and our analogous Article 16 of our Declaration of Rights, Your Honor. So the state police and the district attorney's office are just plowing ahead, ignoring preventive medicine, ignoring the First Amendment requirements I just mentioned. And I hope that this court, I know that this court, and I also am confident in the Superior Court, that they will not allow the government to just profit from its either ignorance or willful disregard of the law and make them submit their own team plan as required by preventive medicine. And I hope that this court will allow Mr. Kearney to get back to investigating and have access to his devices so that he can continue, and also, most importantly, Judge, protect the confidential First Amendment sources that Mr. Kearney has been working with, the bread and butter of an investigative journalist. People have put themselves out there, people who have risked everything to give information in pursuit of the truth, in pursuit of justice. So I ask the court to allow my motion, return his devices. We will stipulate that the devices seized were in fact the devices that are seized from Mr. Kearney's house, person, and car. And there's no issue with, in terms of saying those are not the devices or anything to that sort. So I appreciate the court's attention. Thank you very much, Your Honor.
Thank you, Mr. Brewer.
Thank you.
Counsel.
Your Honor, if I may proceed by first suggesting to the court that I'm going to ask Your Honor to take no action on this motion. Matters have been presented to two Superior Court judges pertaining to Mr. Kearney's activities, and in one instance, the Superior Court judge issued the warrant to seize the actual equipment itself, and the second, Judge Krupp in the Superior Court in Dedham, issued the warrant to search the devices and further issued an impoundment order. So I'm somewhat not at liberty to discuss the content of why we sought the impoundment order or the information sought in the warrant itself or in the affidavit in support of the warrant, Judge. But regardless, my brother speaks of Mr. Kearney's privilege as a journalist. Mr. Kearney identifies himself, Your Honor, alternatively as a journalist, as an activist, as an advocate, and he uses several other terms to identify himself. We're not here, Judge, because of any legitimate journalistic activity on the part of Mr. Kearney. None. We're looking at, strictly, Judge, crimes committed by this defendant, including the intimidation of witnesses. My brother speaks of time-honored privilege or time-honored journalistic activities. Your Honor, there's nothing time-honored about running down the street with a bullhorn screaming at a state trooper who just left the court. There's nothing time-honored, Judge, about an individual going to a local restaurant and telling passersby that they should not go in because there's blood in the pizza. That's what we have here. We have a number of instances very similar to that. We've compiled those various episodes, if you will, for the court's benefit. Regardless, Massachusetts has not recognized a privilege, a journalistic privilege, even if the court wanted to look, at Mr. Kearney in the most favorable light of actually being a journalist. There is no privilege. The Supreme Court back in 1985 was petitioned to come up with a procedure of some type to deal with the privilege, journalistic privilege, and they declined to do so, preferring to utilize common law practices. What we have here, Judge, is also a case that I must suggest is not going to remain in this court for very much longer. I would represent to the court that grand jury proceedings are underway. So regardless, this is a matter that will ultimately not end here. What I would ask Your Honor to do also with respect to the return of the equipment is to deny that motion. The equipment seized is evidence, and not having that equipment has not stopped Mr. Kearney one single bit. He is blogging away on the internet, on a variety of different sites, on a variety of different pages, on Twitter, on YouTube, on a number of other locations as well, from my understanding. And he's going at it several hours a day. He's generating hours worth of materials. We have communications from other individuals, Judge, that suggest there are items that I would best describe as confidential and on Mr. Kearney's phone, not confidential to Mr. Kearney. We're looking at leaked grand jury minutes and things of that nature, Judge. So there's a lot more than any allegation of attorney-client. If the Superior Court reviewing this determines that there could be privileged communications from specific attorneys that Mr. Kearney identifies, the Commonwealth would certainly not be looking at that. That could be appropriate for a taint team. What I can tell you, Your Honor, now is this: not all of the information has yet been mirrored. My brother made a call to me almost immediately, indicated that the defendant had concerns about the treatment and the handling of this information, and with respect for any potential rights that the defendant may claim, and with respect to the judicial system, the state police and the investigators have not perused the material. It is in its pristine form, located on the defendant's devices. But then again, turning those devices back over to the defendant would allow him, if you will, to delete any information stored on them, and would allow for a challenge sometime in the future to say that whatever may be mirrored is not accurate or was created elsewhere, or whatever the case may be. And having that equipment in the possession of the Commonwealth, as is evidence in almost every single case, Judge, that is the appropriate mechanism to employ here. I'm going to suggest respectfully that Your Honor refer this matter to the Superior Court for any further action, and that the court take no action today. Thank you, Your Honor.
Very much.
May I just address briefly some of the things counsel said? Judge, I don't think that just a sort of a verbal aspirational comment, Judge, that, oh, we're going to take this to the grand jury, ought to stop this court in any way, shape, or form. These cases are all district court jurisdiction. The grand jury is doing its job. They're not going to indict him because there's no probable cause that he committed a criminal offense. So the fact that he may wish to bring the case before a grand jury has nothing to do with what's the business at hand here, Your Honor. If they want to do that, that's perfectly fine. But right now, we have a job to do in this court, all of us. And our job is to defend Mr. Kearney's rights, and the court's job, of course, is to make the decision. And we ask that, you put an end to this game of keep away. Let him have his devices back, Your Honor. Let him get back to it. And please enter an order unequivocally declaring that these sources are off limits to these investigators until the Superior Court has addressed these matters, Judge.
Were you advised by the government that they hadn't started the search? There's been no search done?
Yes, Judge. To the government's credit, I reached out to Mr. Mello and said, I want to have a taint team hearing, and the government agreed to wait until this hearing. So I think that agreement expires as of this hearing. And, I appreciate the agreement, but of course, we need a court order on the issue, and we're very earnestly asking the court to enter an order on the docket to that effect. Thank you, Your Honor.
If I may simply say in response, if Your Honor indicates that this matter is being referred to the Superior Court, which the Commonwealth would argue is the proper form, because even under the cases my brother references preventive medicine, it requires action by a Superior Court judge. We would not investigate. We would honor our commitment to further not investigate until this matter is determined by the Superior Court.
All right, so a couple of thoughts. The search warrants, they issued in early October. They were returned, I believe, October 12th. The defendant's motion was filed November 20th, some 5 weeks later as an emergency motion. One could have assumed that the government might have been well into the review, but I understand that hasn't occurred. It seems, at least, if there was an exigent circumstance, if there was one, it was back when this occurred, back in October, not now, under the guise of an emergency motion. To your point, Mr. Bradel, there was an affidavit. I don't find that it was a meaningful supporting affidavit. With your motion, it was rather generalities of categories that the defendant claims or purported privilege to. Search warrant 23SW071 was narrowly tailored in the court's estimation to at least 8 categories of information sought by the government, none of which included the things you referenced: attorney-client information, medical records, journalistic sources. I suspect that any information that is recovered pursuant to that would be the subject of a motion to suppress at some appropriate time in the future. I'll get to you in just a moment.
Sure.
Lastly, your motion, as you both agree on, makes reference to an eventual Superior Court order as to any procedure for review and handling any of these purportedly privileged materials. I don't read preventive medicine, I think, as mandating a taint team review as it did in that case where it involved a post and search. I think the footnote in that case is it could involve a situation where someone's been charged but not yet indicted. But I believe because of that footnote and that the court alluding to, this should be properly based in the Superior Court. I think the defendant should address that issue before the Superior Court. I'll hear you if you had something to add.
Thank you, Your Honor. The Superior Court reference, Judge, in preventive medicine is that only a Superior Court judge can order the tainting. But I think all the rest of it is really properly before this court in terms of seeking return of his devices, and to make a preliminary order, Your Honor, that the investigators not enter the phones or any of the devices or computers until that process is accomplished or addressed.
All right, anything further?
Judge, there's actually one other thing, I'm sorry. Sure. This is just like hot off the presses, as they say, Judge. With respect to a case in which Mr. Kearney is a victim in the West Roxbury District Court, the defense counsel in that case is seeking some raw video of that alleged assault and battery that is in the devices that are in the possession of the Mass State Police. And I believe there was an order entered, and I need to get confirmation of this in writing, but it's my understanding that there was an order issued by the West Roxbury judge saying that Mr. Kearney's devices were to be preserved by the state police and that those videos should be turned over to the defense counsel in that West Roxbury case. So that sort of indicates a whole other aspect, Judge, of these devices, that Mr. Kearney is involved in these 3 other cases where he needs things from the devices to comply with, in this West Roxbury case, to comply with an order from that case, but also that he has ongoing litigation with 2 other matters where he communicates with his attorneys in those matters, and he needs access to the devices to continue to litigate those cases. So there's all sorts of things, Judge, that are in these devices, and I appreciate the court's comment that the investigators are trying to narrowly tailor their search, but that doesn't prevent the idea that they will come across, even accidentally, and that's right in preventive medicine, to avoid the irreparable harm of even an accidental discovery of privileged information, of journalistic sources. All this is privileged information, Your Honor. And that's all stated in my motion that, I did that on purpose to keep the category general, because Mr. Kearney should not have to disclose what's in the phone to stop the investigators from discovering what's in the phone. So that's why I intentionally made those categories very general and vague, Your Honor, is because we're trying to preserve his privacy here in the sense that he's been a journalist for years. He's an investigative journalist. It's readily apparent from any look at his work that he investigates serious matters of public concern that are driven by confidential sources and even police sources who address him and who give him information. So that's why we made it very general. So I don't want you to think that was sort of just because we're just in a rush or something. It's on purpose that I think it needs to be general. And so the affidavit at the end by Mr. Kearney adopts the things that I say factually in the motion. And the things come from him, not from me. And they are kept vague as a necessity. So even though they're narrowly tailoring things, they're still going to look through the entire device, and it's still susceptible to being information that they shouldn't have. So I just wanted to address that, Your Honor. I appreciate your comments. Thank you.
Your Honor, I would agree with my brother in his remarks that some of these sources are police sources. And as a matter of fact, one of those police sources is the reason we have a conspiracy charge now pending against the defendant. And there will also be further charges of conspiracy filed. Your Honor, the Commonwealth has honored its commitment, and it was by way of a telephone call between Mr. Brattle and I to not go into these devices until there was some adjudication by the court. That would not end today if Your Honor would adopt the Commonwealth's request and submit this to the Superior Court. We would not, I would direct the state police to not touch the devices any further, provided that the defendant files within perhaps 1 week within the Superior Court. And if that filing is made, then we would certainly await the Superior Court's decision on that. But there is a lengthy affidavit that has been reviewed by a Superior Court judge, and the order issued as it was.
Judge, I appreciate that, but preventive medicine puts the legal duty on the government to address that with the Superior Court. So I'd ask that be followed.
It seems the 2 of you have made a lot of agreements along the way so far. So,
yes.
So here's what I am going to do. I am respectfully going to deny your emergency motion for protective order today. Hopefully you can work together to seek redress at the Superior Court at your earliest convenience, and maybe you keep the agreement together that the search will not begin, at least until that happens. So I'll leave it to you to get that scheduled, but thank you all for your time.
Thank you, Your Honor.
Court, all rise.
Commonwealth versus Aidan Kearney. Your Honor, Kenneth Mello, Special Prosecutor.
Okay, Mr. Mello?
Good afternoon, Your Honor. Timothy Bradle on behalf of Aidan Kearney, who's here before me for the record.
Okay.
1 through 8, intimidation of a witness. 9 through 13, picketing, and 14 through 16, conspiracy. Mr. Kearney, how do you wish to plead? Guilty or not guilty? Not guilty.
I'll hear you.
Preliminarily, I just would like the record to reflect there had been several conversations between defense counsel and I believe Mr. Brittle and I have actually gotten along quite well thus far anyway. And with respect to the timing of this arraignment, I'd like the record to reflect there's been some public comment that we had represented to the defense that it would not take place until after the Christmas holiday. It was advanced to today, Your Honor, because Mr. Brittle will be away and we're looking to accommodate that schedule. So I would like that to the record reflect that's the reason it's being held when it's being held.
Sure.
In terms of,
We were open for business next week, and we were prepared to do it next week, but I understood Mr. Bradel was going to be away.
Judge, obviously this proceeding today is not being held in a vacuum. Your Honor has heard the facts of the cases that gave rise to the indictments appearing before you today. Unless Your Honor wants a summary, I will not repeat them. It's certainly been discussed publicly in this courtroom before Your Honor.
Right.
And to save...
I don't need a summary. What are you suggesting as conditions?
Your Honor, we're looking for stayaways again. One of the problems we've had, Judge, and I've spoken to Mr. Bradel about this several times, the defendant has, in the Commonwealth's opinion, continued to violate the original conditions of bail, including those that were amended by Your Honor. If Your Honor were to look at the video, provided Bradel has received a copy as well with thumb drive, it's clear that Mr. Kearney is encouraging his minions, his followers, in the context of his blogs and YouTubes, etc., to continue to harass witnesses. He'd make a statement such as, I can't do this, and I'm not telling you to do this, but you can do this, but I'm not saying you can't do this. Don't put words in my mouth. You know, read between the lines. Move between the lines on approaching these witnesses. And he's made similar statements several times, and it's the Commonwealth's contention that this is a very disingenuous way that the defendant is indirectly encouraging others to indirectly harass these witnesses and to intimidate these people and take it in front of their homes, etc. What I can represent, Your Honor, is that we had the grand jury proceedings underway. The Commonwealth was aware that most likely this matter would be before Your Honor or before the Superior Court in relatively short order. We did not proceed with bail revocation in the District Court. However, I can assure Your Honor, and would like the defendant to be on notice, that if there's one more instance where he is online suggesting to people or encouraging people, either directly, disingenuously, or whatever the case may be, and encouraging them in some way to read between the lines, that we will be back before the court seeking a bail revocation as well as a dangerousness hearing. I would ask Your Honor to fashion some type of order that Your Honor believes would be effective in including this defendant from going online and encouraging his followers to essentially continue his pattern of intimidation.
What specifically are you asking me to order?
Judge,
you're asking me to write it.
I'm sorry?
What do you want me to say?
Well, that he should not encourage, intimidate directly or indirectly to have his supporters or encourage his supporters to approach witnesses.
That's what the district court said. You have to stay away and have no contact with the witnesses directly or indirectly.
Or I think perhaps language that prohibits him from encouraging others to do so. And Judge, it may come as far as not even mentioning the names of the victims that appear here. I certainly understand that there are First Amendment arguments that are being made, and we're extremely sensitive to that. We're extremely sensitive to the fact that the defendant claims to be a journalist covering the case involving Karen Reed. We're aware of all of those things. However, the lines blur, the lines cross, and he is hiding behind the guise of a journalist, encouraging basically as an activist. And when he's doing so, that's what we're going to ask Your Honor to preclude him from doing, and perhaps preclude him from mentioning the names of these particular witnesses in a context that would encourage others to approach them or communicate with them. I know it's very difficult. If you see it, you know what it is, but it's very difficult to define it. I think it's extremely disingenuous of the defendant to say he's not engaging in it when he's saying...
Hold on 1 second.
Sorry. All phones off, please.
Go ahead.
Thank you, Your Honor. I think it's extremely disingenuous of this defendant to say, I'm not encouraging this, when he's using terms such as read between the lines.
Okay. All right, Mr. Bradel.
Thank you very much, Your Honor. We would just maintain our objections that we've earlier made before the court as to stay-away orders on probable cause, First Amendment, due process grounds. Ask that you just maintain that for the record in terms of our objection. As to any prior restraint on Mr. Kearney's speech, counsel for the Commonwealth is having trouble articulating it because it's such a problematic area. I think that, how are you going to do this? Mr. Kearney has a First Amendment right to encourage people to exercise their First Amendment rights. I've advised my client about the notion of indirect contact. When you tell someone to contact someone you can't contact on your behalf, that's indirect contact. He can tell people under the First Amendment to, he can share his views with his readers or his viewers, and they can do what they want. He's allowed to encourage them to speak out against what he sees
as corruption, what he sees as mismanagement of the Reed case, etc. I've advised him about the notion of direct contact. We have a disagreement, counsel and I, a respectful disagreement apparently, about what constitutes violating these orders. These orders are, in effect, prior restraints on his First Amendment activity, Your Honor, so they must be narrowly tailored and strictly construed. And in this case, we've discussed it, my client and I think we know as best we can what can and can't be done in terms of speaking out. That's not harassment, that's not witness intimidation, that's journalism. And it's cloaked by the First Amendment, Your Honor. So I would object to any attempt to sort of craft a prior restraint here, Your Honor, and we'd object to any sort of effort in that regard.
All right, your client consents to the stay away, no contact, direct or indirect, with the various victims.
We don't, Your Honor.
Don't.
We object for the record.
You object?
Yes. Yep.
All right, Mr. Mello, under what statute do I have the authority to compel Mr. Kearney to stay away and have no contact with the victims?
Well, Your Honor, it's common practice, as Your Honor is aware.
I'm not talking about common practice, Mr. Mello. I'm talking about what statute authorizes me. This is not a district court proceeding, which is subject to Section 58 of Chapter 276. This is a proceeding under Section 57 of Chapter 276, or I have authority under Section 87 of Chapter 276 to impose conditions with consent. You don't have to ask for personal recognizance. You can ask for bail. You can ask for dangerousness if you think that's appropriate. But under what statute do I have the authority to set conditions to which Mr. Kearney does not consent?
I believe that, well, obviously, Your Honor, you would have to sign the terms and conditions of bail. We could do that through the context of a dangerousness hearing, which the Commonwealth prefers not to employ at this point in time.
You haven't moved for dangerousness.
I'm sorry?
You haven't moved for dangerousness. You haven't invoked 58A.
Right, we have not.
Right. So what statute authorizes me, absent Section 58A, to impose conditions on Mr. Kearney's release if you're asking or consenting to personal recognizance?
I think.
Or even if you're stipulating to a particular bail. Section 87 is different than Section 57 is different than Section 58.
I understand that, Your Honor. I think in total, both Sections 57 and 58 would give Your Honor the authority to impose certain conditions, especially when it comes to the witnesses. I think the challenge here, Judge, is we have competing interests, a claim of journalism and personal...
You said 57 and 58 together give the court authority. Section 58 applies to the district court, right? And Section 57 applies to the Superior Court, right? And 58 has a provision in it that says, if the judge, I'm going to paraphrase now, of the district court determines it to be necessary, the defendant may be ordered to abide by specified restrictions on his personal associations or conduct. I quote that now to you in Section 58. I quoted it before in my earlier decision, right? Section 57 has no such provision, right?
I would argue, Your Honor, that although it indicates that the district court judge may do it, certainly comes under the purview of the Superior Court. I don't think the intent of the legislature was to narrow the authority of this particular court and make it less than that of the district court. It's normally that these matters are instituted in the district court before they arrive at Your Honor's level, and I believe that's why the legislature perhaps put that language in, but I don't believe it precludes this court from doing so either.
You have a case that says that? I mean, the statutes are different.
I wasn't expecting...
You came in asking me to set up release conditions that you knew Mr. Kearney wasn't going to consent to. He objected to it before in the district court.
Judge...
I think the district court was entirely within its power to set that condition, and it was appropriate for me to uphold that condition. I think it's an appropriate condition to be imposed in this case, in the Superior Court, but I don't know if I have the power to do it under the statutes, and I'm looking for some authority that you might have indicating that I have the power to do it.
What I would ask Your Honor to order is that he comply with all laws. The general provisions when someone is released on bail, the Commonwealth will take it from there
if he's released on bail. He doesn't have to sign anything with respect to personal recognizance, right?
No.
You're asking me to release him on his personal recognizance, right? You're not asking for me to set bail, and you're not giving me any authority to indicate that I have the right or the power to impose conditions on his release.
I would suggest a dollar bail, Judge, if that's what...
Well, excuse me for a second. I have the power to impose conditions of release under Section 87, including stay away, no contact orders, with the defendant's consent, right?
Understood.
Okay. So...
I realize I can appear before Your Honor asking for a high bail, which I don't believe the Commonwealth would be honest to do. We don't expect Mr. Kearney to not appear, at least at this point. The normal condition of release, Judge, would be that he comply with all the statutes. If Your Honor is not inclined at this point in time to fashion an order, the Commonwealth certainly appreciates the court's position.
I don't have to order him not to commit crimes. If he commits another crime, he'll be in front of the court on a violation notice. I don't have to order that. He's already subject to the law as everybody else is.
We would indicate that's an indirect violation and we would proceed back in court, Judge. I'll accept Your Honor's ruling.
Okay. Anything further, Mr. Bradel?
Nothing further, Your Honor. Thank you.
All right. I'm going to, on the Commonwealth's recommendation, release Mr. Kearney on personal recognizance. Commonwealth not now looking for bail. I do find that the Commonwealth has asked for conditions to be set on Mr. Kearney's release, but the Commonwealth provides me with no authority that I have the power to do that over Mr. Kearney's objection. The statutes are a little bit convoluted. General Laws 276, Section 87 allows me to set conditions on release if the defendant consents to those conditions. Here, Mr. Kearney doesn't consent to those conditions, and the provision in Chapter 276, Section 58, Paragraph 1, last sentence, which I quoted before, authorizes the district court to set conditions on personal association or conduct, including avoiding all contact with an alleged victim of a crime. That provision does not appear in Section 57, which is the provision that applies in this case for the setting of bail in the Superior Court. And while that provision, Section 57, authorizes the setting of conditions in 209A and related type cases, this is not one of those enumerated in Section 57, which allows me to set conditions on Mr. Kearney's bail over his objection. This is a bail setting under the first paragraph of Section 57, which does not have the same language as in Section 58. So I am hamstrung, at least with the authority given to me by the Commonwealth. So I'm going to release Mr. Kearney on bail. He knows that if he commits a crime, he'll be back in front of the court in quick order. So you'll make sure of that, Mr. Mello, I'm sure. Anything else? We need a pretrial conference and a pretrial hearing date.
I would suggest something in February for pretrial conference. Mr. Kearney, you're being released on your own personal recognizance. Please be advised, while on personal, if you're arrested for a new crime, you can be held without bail for up to 90 days, and your failure to appear to court appearance result in a fine of up to $50,000 and/or 5 years in jail. Your matters continued at 2:16 at 2 p.m. for pretrial conference and 4:23 at 2 p.m. for pretrial hearing.
All right, thank you.
Thank you.